Donald Trump's legal team says it will appeal the New York jury's verdict that found Trump guilty of those 34 counts of falsifying business records. So what exactly would that process look like? Well, first, Donald Trump has to wait for his sentencing, which is scheduled for July 11th. Within 30 days of that sentencing, Trump has to file a notice of appeal. And then Trump's team has 6 months to submit his appeal and other relevant trial documents. A process called, quote, perfecting the appeal. Trump's team would have 6 months to do this. Now, the case will then go before a 5-judge appeals panel, which will decide whether to uphold or overturn Trump's conviction. If the panel upholds the jury's verdict, Trump can seek permission to have New York's highest court consider his appeal. This court can decide to hear the case or forgo it altogether. With me to discuss all of this and more, criminal defense attorney and former prosecutor for the Manhattan DA's office, Jeremy Salon, trial attorney Misty Marris, and criminal defense attorney Bernardo Alona. Guys, thanks so much. There's a lot of politics. There's no question about that. We want to talk about the legal here. And I want to start with what Todd Blanche said about the appeals process. He said that he's going to try and file motions before a formal appeal. What does that mean? What does it look like? Can it work?
Yeah, so defense attorneys commonly do this. This is routine. So the first step is for the defense attorney to go to the trial judge. So this is Judge Marchand, and say that this verdict was what's called against the weight of the evidence. Basically, he says the jury got it wrong, that there was not enough evidence for the jury to convict. They asked the judge to overturn the verdict. That's the first avenue. It's very unlikely for that to succeed. Almost always that motion gets denied unless there's a very extreme situation. Then the next step, as you said, is to go to the appellate division. The appellate division looks at the case, looks at the record, and will make a determination about whether or not there were errors of law. They don't question the jury. The jury is the finder of fact. They say, was there something that was overly prejudicial? Should evidence have come into the courtroom that didn't, or did something come in that shouldn't have? Were the jury instructions proper? Those are all the issues that the appellate court will look at. So it's two different aspects, and it is routine for defense attorneys to go both routes.
Now, Jeremy, one of the questions that I keep getting asked the last 24 hours, when is this all going to happen? How long does it take? How long?
It's already happening, and it probably already happened or started to happen before there was a verdict. They saw the writing on the wall. You know, I think the Mother Teresa comment was really that throw out there, like, I can't win. I'm sort of getting ready to say I'm not as good as them. I got a worse basketball team, baseball team. I'm going to lose, giving that preemptory, I'm the victim here, and they already started that. Now, they're going to file within that time frame, and it could take certainly well more than a year on an appeal, and they're going to lose. This isn't new law. It's unique in the sense that it involves the former president. It's unique in the sense that maybe we're dealing with federal election law, but it's not. Falsifying business records is as old as the penal law, relatively speaking, but this is not something that's fresh and like, wow, we need a new look at this. So it's going to take that whole year time, maybe more, maybe less. Will the Court of Appeals take such a case? Maybe, maybe not, but this is really mundane and typical.
I want to play something for you that Speaker Mike Johnson said this morning on Fox News. Take a listen.
I do believe the Supreme Court should step in. Obviously, this is totally unprecedented, and it's dangerous to our system. I think that the justices on the court, I know many of them personally, I think they're deeply concerned about that as we are. So I think they'll set this straight, but it's going to take a while.
I wish we had an ISO cam on your face as he was speaking. Based on your reaction, what you seem perplexed by what he's laying out.
Sir, sit down.
Well, explain.
So in terms of what happened at the trial, there's also one more motion that is going to be filed before Judge Marchand, and that's the motion to set aside the verdict. And Judge Marchand is going to make that decision. But there's only 3 grounds that you can set aside the verdict before sentencing, and that has to deal with juror misconduct, has to do with newly discovered evidence, or whether there's an error so big at trial that if it were to be appealed, that it will be an automatic reversal. So unlikely, none of those 3 happened during trial. So just like how Jeremy said and just how Misty said, you have the appellate process. The appellate process is going to go through the appellate division first. If the appellate decision, then of course they'll grant leave to see if they'll go to the Court of Appeals. But that's not going to happen here. I don't think that there's such a big issue that the New York Court of Appeals is going to step in and reverse the conviction itself. And just even if either of these courts step in, it doesn't mean that they're going to dismiss the case. If anything, they're going to send it back to the trial court. But the United States Supreme Court, that's packed with Trump's nominees, is not going to make a decision in this New York State criminal conviction.
Missy, Todd Blanche, Trump's lead attorney in this, sat down, fascinating conversation with our colleague Caitlin Collins last night. I want you to take a listen to this.
Do you accept that he did have his day in court and it was a jury of his peers that made this decision?
No, not at all. We were indicted for for conduct that happened in 2015, 16, 17, in a jurisdiction that it was very hard for us to get a fair trial. Every single person on that jury knew Donald Trump, either as president, as candidate, from The Apprentice, and so I don't accept that this was a fair place to try.
So there's a lot to unpack there. First, Blanche says the trial was unfair because Trump was indicted for conduct that happened in 2015, 16, and 17. Blanche also says it was an unfair trial because jurors knew Donald Trump as president and from The Apprentice. But wouldn't that be true anywhere in the country?
Yes. So first of all, I think at a bare minimum, you have to say we respect the jury process and we respect that the jury returned this verdict. Now, if he wants to say there are appellate issues that we're going to pursue, of course, any defense attorney is going to pursue those issues. They're going to say we should have had a change of venue. I don't particularly think that holds water. We're talking about making a change of venue argument based on just the makeup of the political spectrum in New York. That is not a basis. There has to be something that is reasonably likely to lead to a biased jury. It's just not going to hold water in this case. So that's one avenue. But he's going to say that there were a bunch of evidentiary decisions that went against Donald Trump. That's what his job is to do in the appellate process. I actually think there is one appellate issue. I just want to flag it. Whether or not a New York State election law could be the predicate crime for this because he was running for federal office. I think that's the primary appellate issue that doesn't really get into the weeds of the case, doesn't really get into the evidentiary decisions, but it would be a novel issue for the court to decide.
Jeremy, you were scribbling furiously during the Blanche comments. I want to ask you about that in a second. But to Mrs. Point, how are you so certain there is no kind of grounds for a successful appeal here?
You're not certain, and that's why you appeal.
Yeah.
Though you would appeal regardless, because that's what you do very often, because there's something you may miss, and you look back at that transcript, and very often it's not the trial attorney, though in some cases it is, it's an appellate lawyer who's skilled in the appellate work to look through that transcript and find things that maybe the trial attorney did not see or was unaware of. And also, you don't want to be looking at your own potential errors and mistakes. You want a fresh set of eyes to do so. But to the point here, I pulled out a few things. First of all, it's not were indicted. It was Donald Trump was indicted by a grand jury. Conduct in 16 and 17, it's called the statute of limitations, and you failed on that front, so the statute of limitations had not run. By his conclusion, meaning Blanche, if this was in Alabama, therefore, and it was a Democrat, would he say the same thing was unfair? The bottom line is, with all due respect to Mr. Blanche, he did a poor job on cross-examination. He poorly prepared or prepped or was ready for Bob Costello, who I wouldn't just say dropped the ball, was a potential double or triple, maybe not a home run, but he couldn't even get on base because his misconduct and the way he behaved was out of line. Using things like the gloat, comparing Michael Cohen, who really did a terrific job, and that's credit to Steinglass and that team, as sort of the Michael Jordan of lies. What did that get him? Being cute and funny? It didn't do anything. The prosecution was methodical. They were deliberate, boring at times, but they did their job. And unfortunately for Mr. Blanche, he was meandering. His closing was and when he cross-examined Michael Cohen, his last question, I won't pull it up, gave Michael Cohen the ability to sort of build himself right back up. He left a question out there that was open-ended, not direct, what you do in leading as a defense attorney, and gave him the power to rehabilitate himself. He failed.
Let's be honest. Tal Blanche was out-lawyered. He was out-lawyered in that courtroom.
Because he had a great reputation coming in.
In federal court. This is state court. This is a completely different ball game. A completely different ball game. So he is a former federal prosecutor. But when you're dealing with state court, and that's my playground. I've been practicing in state court for 20 years now. He was out-lawyered in state court. Josh Steinglass, you got to think he got home court advantage in the sense that he's been at that prosecutor's office. He's been dealing with New York County jurors during his entire career. He knows the judge. He knows how things play out inside of the courtroom. And in terms of Tal Blanche, I knew that he was in trouble doing his opening statement. That's his first failure right there. His opening statement where he opened up the door in the sense that he started talking automatically. Stormy Daniels, this never happened. Had you not addressed your opening statement like that and just left it just plain as we normally do, you have to prove your case beyond a reasonable doubt, keep an open mind. Donald Trump, yes, he's presumed innocent. He has that cloak of presumption of innocence. Then you wouldn't have gotten into the Stormy Daniels details of this sexual encounter. I wouldn't be hearing how Donald Trump got his butt smacked with a magazine. So that's number one. Number two, Michael Cohen, that cross-examination, I was there for all 4 days. Horrible. Horrible. You humanize him. At one point, Phil, I started feeling bad for Michael Cohen, like sorry for him. I shouldn't be feeling like that. So imagine if I did, imagine a jury.
Yeah.
Because I'm in a game.
He alluded to the fact he had to co-litigate in this case. It was the former president, Misty, Jeremy, Bernardo. Thank you guys very much.